Let's jump right into this explainer. We're looking at a deeply fascinating, honestly mind-bending 1997 case from the South African Constitutional Court called the State versus Coetzee. It's basically a story of what happens when old authoritarian laws violently collide with a brand new, human rights-driven constitution. So, put yourself in the shoes of the accused for a second. Imagine walking into a courtroom, taking a seat, and suddenly realizing the state doesn't actually have to prove you committed the crime. Nope. Instead, the judge looks right at you and says, hey, it's your job to prove you didn't do it. And if you can't prove your innocence perfectly, you're going to prison. Sounds like a dystopian nightmare, right? But as we'll see, this was a very real, everyday legal reality for decades. Which brings us to the core legal concept we're tackling today, the reverse onus. Historically, prosecutors absolutely loved this. Why? Because it made getting convictions incredibly easy. Instead of the state spending all this time and money gathering complex evidence to prove every single element of a crime, the law just created a shortcut. It shifted all the heavy lifting right onto the person standing trial. Here's our roadmap for decoding all of this. We'll start with the golden rule of justice, look at the clash of legal eras, dive into the fraud presumption, explore the corporate director's dilemma, weigh rights versus state needs, and finally, get to the final constitutional verdict. Starting right off with Section 1, the golden rule of justice. Okay, so the absolute bedrock of a fair and democratic system is that the state carries the burden of proving your guilt. And they can't just prove it's, kind of likely you did it. They have to prove it beyond a reasonable doubt. This is a massive shield. It protects you and me from the immense, overpowering resources of the state. It essentially guarantees that if there's even a shadow of a valid doubt about your guilt, you go free. Moving on to Section 2, let's look at the clash of legal eras. You see, the court in 1997 faced this incredible tension. On one side of the ring, you have the 1977 Criminal Procedure Act, drafted during an era of unchecked parliamentary sovereignty. That basically meant the government could write whatever laws it wanted to make policing easy. But on the other side, the 1993 Interim Constitution. This introduced judicial review and firmly entrenched fundamental human rights, like the absolute right to a fair trial. As Justice Langa pointed out, the court was dealing with a massive legal hangover. They were forced to evaluate these old, frankly draconian laws that simply didn't belong in a free society anymore. The state was still trying to use these old rules to prosecute people, but now, finally, the accused could point to the new Constitution and say, wait a minute, this is fundamentally unfair. Which brings us to Section 3, the fraud presumption. Let's look at the first major constitutional trap embedded in the old law, Section 245. Under this rule, which dealt with crimes like fraud, if you made a statement that turned out to be false, the state didn't actually have to prove you meant to lie. Usually, intent is a totally required element of fraud. You have to have a guilty mind. But under this section, the state just pointed out the statement was false, and boom, the law automatically presumed you were a liar with a guilty mind. You were literally deemed guilty unless you could somehow prove a negative about your own internal state of mind. And, get this, you had to prove it on a balance of probabilities. If the trial ended and the judge was completely on the fence, like maybe you knew it was false or maybe it was just a completely honest mistake, the law forced the judge to convict you, simply because you hadn't actively proven your innocence. Let's shift gears to Section 4, the corporate director's dilemma. This one is an even more terrifying trap. Consider how a corporate director could automatically be deemed guilty of their company's crimes under Section 332, subsection 5. Say some low-level employee commits fraud on behalf of the company. If you were a director, or even just a servant of that corporate body at the time, the state could charge you personally. You were deemed guilty just by holding office. No way around it. Well, actually, scratch that. The law did give you a way out, but look at how ridiculously steep this hill is to climb. To escape absolute liability and potential prison time, you were forced to prove two things. First, that you didn't participate in the crime, and second, that you had absolutely no power to prevent it. Again, the burden was entirely on the accused to somehow prove their way out of a conviction. So here is the truly terrifying reality. If your proof wasn't perfectly convincing, you were convicted. Think about that for a second. You present your defense, and the judge thinks, well, there's a reasonable doubt here. I'm not totally sure this director could have stopped the crime. In a normal system, reasonable doubt means you go free. But under these reverse onus provisions, because the burden was on you to prove your innocence, Having a judge merely doubt your guilt wasn't enough. You went to jail anyway. The Constitutional Court actually looked heavily at international law to resolve this, relying on this powerful logic from Canadian Chief Justice Dickson. The court confirmed that the exact phrasing of the law didn't matter. Whether you call it a presumption, a defense, or an excuse, if the final effect is that a person can be convicted while a reasonable doubt exists, then the presumption of innocence has been completely shattered. This brings us to Section 5, weighing rights versus state needs. Now, you might be thinking, doesn't the government have a legitimate need to fight complex corporate crimes? In constitutional law, rights aren't always absolute. Under the limitation of rights criteria at the time, rights could be limited, sure, but only if the state could prove the limitation was reasonable, justifiable in an open and democratic society, and strictly necessary. And here we see the ultimate showdown of the case. The state argued, look, prosecuting corporate crime and fraud is just too incredibly hard without these shortcuts. Corporate veils are thick, proving what a director knew is practically impossible. But Justice Langa and the court pushed back hard. They ruled that mere administrative difficulty does not justify reversing the onus of proof. The court pointed out that if the state wants to regulate corporations, they can create strict reporting duties or specific regulatory offenses. What they absolutely cannot do is use a constitutional shortcut that risks sending innocent people to jail. Finally, Section 6, the final constitutional verdict. The court struck down both sections completely. They actually looked at whether they could just surgically edit the text to fix the laws, but decided that doing so would essentially be rewriting the law from scratch. And that's Parliament's job, not the courts. So they refused to let the state rely on unconstitutional shortcuts to secure criminal convictions, which sent a massive shockwave straight through the prosecution services. This ruling cemented a profound legacy. It established a hard boundary. State convenience and the desire for easy convictions can never trump the fundamental rights and freedom of the individual. In a true democracy, the state simply has to do the hard work of proving its case. Period. So I'll leave you with this thought to wrap up our explainer. When the burden of proof shifts to the accused, what actually happens to our liberty? If the government can simply deem you guilty and force you to prove otherwise, doesn't the very concept of a fair trial just disappear? It's a powerful reminder of why the presumption of innocence is the ultimate bedrock of a free society. Thanks so much for joining me to explore this incredibly pivotal piece of legal history.